Well, good morning, everyone. This is the New Hampshire Tech Alliance HR Exchange. I'm Jim Reedy, and from the Bat Cave here in my library at Sheehan Finney. We are just thrilled to have our October event, October 12th. It's amazing, wasn't it just August yesterday? But we're going to be talking about a very important topic, paid family leave as it comes to New Hampshire and what employers need to know. This is a hot topic, and we've got a great presenter who presented on this last week with the Manchester Area Human Resources Association. And it's lots and lots of questions, for those that went through this in Massachusetts and still go through this in Massachusetts with their paid family leave law, you know that the questions are almost endless. So we're still waiting for the room to fill up a little bit here. We've got 150 people so far. I think we've got over 300 registered. But as we do, I'm going to go through a couple of housekeeping items. So the first is our events starting next month. And so next month on the 16th of November, we've got WARN, Worker Adjustment Retraining and Notification Act, and that is legal pitfalls to avoid with layoffs, furloughs, and organizational changes. As we all know, or you should know in HR, November is the high season for layoffs, and it starts from November through early January. And I read an article in Market Watch yesterday suggesting that it's coming sooner, and we're already seeing that with a few clients, post-COVID hangover and other issues with the economy. But this article in Market Watch was interesting. It said 50% of the CEOs that were interviewed said that remote workers will be the first to go, which is a bit of a head scratcher when you think of it, because and oftentimes out of necessity or because you want to retain someone, you allow them to work remotely. So why is it that you want to save on commercial real estate? Why is it you let them go? But that was the article, and it's pretty interesting. So Brian Bouchard will be here to talk about that in November. And then as we do every year, the top 10 wage and hour violations in New Hampshire and from the USDOL and how to avoid them. That's December 14th. And we will be talking about that and related wage and hour issues. As Andrea knows, just yesterday, our friends at USDOL issued their proposed rule with regard to going back to the pre-Trump era definition of independent contractors and misplaced or misclassified workers. U.S. Department of Labor this year hired 100 new inspectors, and they're out looking at joint employment. They're looking at misclassified workers and other wage and hour violations that perhaps occurred during the pandemic. But still, those can be expensive. So we're going to be doing that in December. And then we've got a full slate through June of next year, but that's it for the update for what's coming next. Now, this program, like all of our programs, has HRCI credits. That is at the end of the program. And so you'll see that. Also, we will be sending out to you a PDF of Andrea's materials and actually a copy of the video as well. So you can quiz your friends on New Hampshire paid family leave. So without further ado, I would like to introduce my friend and colleague from the firm of Cook Little, attorney Andrea Chatfield. Andrea, many of you know, and if you don't, shame on you, because she's amazing. She is a management side employment lawyer, and she's got a very long bio, but I'm going to skip to the most important part. She is the State Council of Government Relations and Legislative Chair. She's the BIA Vice Chair of the HR, Healthcare, and Workforce Development Committee. And as of last week, yes, drum roll, please, she is the 2022 HR Hero from the Granite State HR Conference, and certainly well-deserved for all of her work that she's done throughout the years for employers in New Hampshire and beyond. So I want to just turn this program over to Andrea. I encourage you to listen, not look at your phone, not look at your email, keep your door closed. This is very important, and she's on top of this, this very important issue, as employers in New Hampshire do need to know about this. Turning over to you, Andrea.
Thank you, Jim. And yeah, the feeling's mutual. And one of the reasons that I think that all the work I've done for the SHRM chapters is really because Jim is an inspiration for all of that. So He's somebody who has also contributed so much to the HR community. So I'm very happy to be here. I was happy to be invited to do this, and excited to talk about this new program. We're still in the early stages of what this whole insurance plan is. It's just being rolled out now, and there are some resources that are already online that you can access easily, and there will be more information as we go. There's more information to come over the next few months, but this is hopefully what we know now, that my presentation will reflect what we know now, and what we know now, there's a lot to unpack here. So we're going to start the beginning. In June of 2021, Governor Sununu signed into law the PFMLI plan. It's a long acronym. It's a little awkward acronym too, but basically it's an insurance plan, and it's for employers for throughout the state. Now, for the state employees, those employees who are employed by the state of New Hampshire, they are automatically covered on this insurance plan. But for every other employer in the state, private, for-profit, nonprofit, public, towns, municipalities, county governments, for those employers, this plan is completely voluntary. You can choose to purchase it or not as an employer. And so what it means is that if you do purchase the plan, then it basically, you can choose between a 6-week or 12 weeks of benefits package. That's the way it's divided up. And that's because the original law provided that there would be an insurance plan available for purchase to employers in the state that would allow at least 6 weeks of wage replacement benefits and leave for employees for qualifying reasons. And when MetLife proposed to offer the plan to the state, they included a 12-week benefit package as well, which is kind of, I think, interesting and helpful, depending on the cost of it, of course. So there's also a unique feature in that the law also allows New Hampshire employees or individuals themselves to voluntarily purchase an individual coverage plan, which is something that is unique to our state. We'll talk more about that and what that involves. So when the law was passed, the bid was put out for insurance companies to bid to be the insurance company that provides this insurance plan. MetLife was the approved plan for the state. So MetLife automatically provides this insurance to all the state employees, and the state government pays for that. And then because that sets up, remember, this is an insurance plan, that sets up a risk pool that's big enough for then MetLife to figure out what group premiums would be for other employers who want to purchase the plan or individual plans. Right now, the best resource for learning more about this, other than today, is the there's a paidfamilymedicalleave.nh.gov. So there's a website that the state has put up. It has basic information on it. It has a bunch of FAQs right now, which I'm under the impression they will be updating periodically. And then MetLife also has a web page. And when you do get a copy of the PowerPoint presentation, you'll see that those links there are links, hopefully, that you can click on. The state website also had provided webinars for employers back in September. Those have already happened, but those were basically intro to what the whole thing was about. Hopefully I can give you some information. I will be giving you some information from those sessions today, but I suspect they will be adding more sessions, more webinars as more information is known about how this is all going to be implemented. So keep an eye on their website for that. So what does this mean? So what basically the insurance provides would be wage replacement benefits when an employee needs time off for birth, adoption, foster care, placement of a child, or to care for that child during their first year, care for employee's family member who has a serious health condition, and care for a spouse, child, or parent who's in the military. And this is because they have a serious health condition that qualifies, or because there was an urgent demand, what the FMLA usually refers to as an exigency. Someone's being called up pretty quickly and you need to scramble to help your your son, daughter, or parent or spouse and get childcare arrangement, get things done. As a matter of fact, there was just a recent call up, a sudden call up of a bunch of our National Guard to go and help out with the Florida hurricane. So that might be one of those qualifying reasons somebody needs leave to help their family member get ready to go on duty. And then also the insurance plan covers an employee who needs time off for their own serious health condition, and that's non-work related. And also serious health condition includes pregnancy for female employees. And that would be coverage only if the employer does not already offer short-term disability or long-term disability insurance. So that's what the plan provides. That's the type of leave it provides. And employers, again, who choose to participate or purchase one of these plans, you can also choose whether you, the employer, want to pay the premiums or share or shift the cost of the premiums to employees. So it'll be interesting to see how that shakes out a little bit. And I think it all depends upon what the cost will be. The good thing to know is that the MetLife is now opening up for requests for pricing. So you can get quotes now from them on what a plan would cost for your workplace or your workforce. Keep in mind that it does cover both full-time and part-time employees, that they would all be covered under the plan. Then what is it that they get? If you do purchase a plan, or if an individual purchases their own plan, then the benefit is basically a wage replacement benefit for either the 6 weeks or the 12 weeks, depending on which one you choose. And the wage replacement benefit is basically 60% of an employee's average weekly wage, capped at the Social Security wage cap, which for 2022 is $147,000. So 60% of the employee's average weekly wage would be the wage replacement benefit. So this works a lot like a short-term disability plan, if you have those in your workplace, whereby if you're ill and you have a qualifying disability, you apply to the insurance company and you get a benefit. And depending on how the plan is arranged, it could be 60% or 75% of your average weekly wage. And that would be the benefit you get for a period of time. And then the employee, though, would file the claim for benefits with the insurance company. So the insurance company is paying the wage replacement benefit. You or the individual are paying the premium for this insurance benefit. And then the employee, however, you can also make sure that the employee does obviously provide you with notice of the need for leave, and because you're going to have to know about that as well for other reasons, right? So a couple of other things. This is interesting. The insurance covers full and part-time employees who are performing services in New Hampshire for an employer with a physical location in New Hampshire. So those are the types of workers that can be covered under this plan. They have to be performing services in New Hampshire, or primarily in New Hampshire, and it has to be for an employer that has a physical location in New Hampshire. So if you are an employer, you're physically located in New Hampshire, but your employees are all out of state, remotely working, they would not qualify for coverage under this plan. If your employer is not physically located in New Hampshire, okay, and has employees who are working remotely in New Hampshire, they would not be covered either. So you have to meet those two conditions, and it's similar to how the Mass PFML works, but it is different because under the Mass law, Mass PFMLA covers employees who are working in Massachusetts or primarily working in Massachusetts. But it applies to any employer that has massive employees in Massachusetts, not just employers located in Massachusetts. So the Mass law covers this a little bit more broadly. But if you have employees in both New Hampshire and Mass, and you are physically located in New Hampshire, keep in mind that you're not going to be able to double cover an employee. You have to basically report an employee's wages to one state for like purposes of unemployment. And that's the state that will determine where they work. The enrollment for the plan begins in December 1st. So with coverage beginning January 1st, that's the earliest that you can have coverage start under the group plans, the employer plans. And then thereafter, though, you don't have to, you can actually, as an employer, enroll anytime thereafter. So if you decide you want to wait 6 months and maybe start your plan July 1st, that's fine. You can then enroll at any time. There is a 7-day elimination period per benefit period for both the group and the individual plans. This is something that for the individual plans, I will talk about that enrollment on my next slide, but for the group plans, anytime after January 1st, you can have coverage start. Then this is something that you want to pay close attention to. For any employer that has 50 or more employees, you're considered a large employer. And a large employer is not just you have 50 employees in one spot, but you have a total of 50 employees, no matter where they are located. So if you are a large employer and you decide and you choose to purchase one of these plans, you will be obligated to provide the leave under the plan and to protect the person's job. They will have job reinstatement rights. You have to continue their health insurance coverage, and you have to ensure that they are not retaliated against for taking time for the leave or for taking the benefits under the plan. And that's pursuant to a new state law, RSA 275:37-D. And that actually is a live link to that, so you can see how that reads. But so it's again, it's imposing these requirements on large employers, but only once you have chosen to purchase the insurance plan. Also, you can require that any paid leave under the insurance plan be concurrent with any other leaves you have under collective bargaining agreements or other employer established leave policies or the FMLA. So you have an FMLA policy, then the leave and the benefits under the Granite State PFMLI can run concurrently with your FMLA leave. And you want to make sure you provide adequate notices to employees about that. But if you have coverage under a separate short-term disability insurance plan, or the person's out because of workers' comp and they're getting workers' comp benefits, then the insurance plan benefits would not apply and the insurance leave would not apply. And then you can also require or allow employees to use available PTO during a leave to cover that 7-day elimination period, or you allow them to use a portion of their PTO or vacation or sick time to sort of top off their PFMLI benefits. So to go from 60 to 100%. Oh, and just to let you know, I'm glad you're sending in some questions. That's great. We will be reserving time at the end of my presentation to go through your questions. So I'm going to run through my presentation and then we're going to go through your questions. And I have a timer on to make sure that I stop enough so make sure you guys have plenty of time to get, we have plenty of time to get to your questions. I want to spend talking a little bit about the individual plans. This is such a unique feature. Usually when you have a short-term disability plan, you don't have the ability for employees to purchase an individual plan, but this is something new and it's interesting. So the insurance scheme allows people who work for employers that don't purchase PFMLI or don't have comparable paid leave benefits to purchase their own plan. They can take with them wherever they go in New Hampshire, obviously. And it's available to New Hampshire employees who, again, work for New Hampshire employers, and they can purchase their own plan. And under the law, the premium for the individual plans cannot exceed $5 per week to the employees. So this would only be a 6-week benefit plan only. They don't have the option under the individual plans to purchase a 12-week plan. They would have to get the 6-week plan only. And also they are subject to a one-time 7-month waiting period. So they have to contribute to the plan, but they have to wait 7 months before they can actually apply for benefits. And they still also would have the 7 calendar day elimination period per benefit period. They can start enrolling after January 1st. And then after that, they only have a 60-day enrollment period annually. So if they miss the first 60-day window in 2023, they have to wait till 2024 to the next 60-day window. So that's different from the group plans. The premiums are then paid directly to MetLife. If the employee works for a large employer having 50 or more total employees, and that large employer does not purchase PFMLI, the individual can purchase their own individual plan, and the premiums would have to be through payroll deduction. So the large employers would still be obligated, even if they choose not to get PFMLI, they're still obligated to set up the payroll deduction for the individual premium plans. Now, how are you going to know that a person has or is purchasing an individual plan? Well, MetLife's going to tell you that, because when somebody applies to get an individual plan, they have to give MetLife contact information for their employer, because MetLife has to verify, one, that, well, first of all, what's the person's average weekly wages, so they know how to calculate what the benefit would be, and two, that the employer doesn't have PFMLI or some other comparable paid leave program that therefore that could disqualify the employee from having an individual plan. So MetLife's going to tell you, hey, you have this employee who's going to have an individual plan, verify this information, and if the person qualifies, you're going to have to make the payroll deduction. And also, if the employee files for a claim of benefits under that insurance, their individual plan, MetLife is going to contact you because they're going to need information for the processing of the claim. And as a large employer, and as any employer, will be obligated to cooperate with MetLife in that situation. Small employers, yes, small employers that have less than 50 total employees, you also can purchase an FMLI group coverage plan for your employees, excuse me. And small employers, you are not, even though you're not required to do the payroll deduction for employees who purchase individual plans, if you, the small employer, purchase a PFMLI for your employees, you will have to do payroll deduction if you shift some of the cost of the premiums to your employees. But you also, like large employers, can require PFMLI to run concurrently with collective bargaining agreements, your other established leave plans as well. And MetLife says that they will give quotes on employer plans having as little as one life, they call it, or one employee, which in my mind kind of says, well, what's that difference between that and an individual plan? That's a question MetLife will have to be able to answer. I can't answer that one for you. But the interesting thing is that job protection and anti-retaliation requirements don't apply to small employers. When you read RSA 275-37D, it only applies to employers with 50 or more employees. So even though those job protection and anti-retaliation requirements don't apply to small employers, you still want to use caution, I think. Small employers, you really should still make your best efforts to protect the person's job and also to not retaliate against them, because they could also be qualifying under anti-discrimination rules or ADA or have a claim for wrongful discharge. So you still want to use caution. And certainly if you were going to take some adverse action against a person as a small employer for using the PFMLI benefits, then certainly I would suggest you call legal counsel before doing anything like that. A quick slide, because I'm not a tax expert, on the tax issues regarding these PFMLI plans. So the fact that the purchasing the plan is completely voluntary for most all employers in the state is great. But the way we tried the law is set up to incentivize employers to get on board with this, because the more employers that participate, the more lives covered by the plans, the more viable they are financially. So in order to incentivize employers to sign up for these plans and to pay for them, there is a tax credit that for-profit employers can get on their New Hampshire business enterprise tax. And it's 50% of the premiums that are paid by employers under the 6-week plan. You also get the same tax credit under the 12-week plan, but it's prorated to be 50% of the premiums you pay for 6-week plans. It's not for the whole 12-week plan, but at least you get the 6-week plan. So that could be a good chunk of change. And it could be applied as a tax credit on your New Hampshire business enterprise tax. So that's something to hopefully incentivize. And that applies to both large and small employers, but obviously only applies to for-profit employers, since nonprofits don't pay the enterprise tax. We're waiting for more information from the state on how to apply for the tax credit. Obviously, would probably be for 2024, not 2023. And we hope to see more information from the state about that in November. The premiums for the PFMLI plans are paid on a from net income, so they're paid post-tax. And also the taxability of the benefits that are paid to employees themselves, you would need to consult with your tax professionals about that. That was something that MetLife couldn't answer, and unfortunately neither can I, since I don't practice tax law, but you want to involve your CPA in understanding all the tax ramifications there. Okay, Granite State PFMLI is something that is new to the state, and it provides a pay benefit, but it also provides some leave protections if you're a large employer. So the question is, well, how does it interplay with other leave laws? So I want to first talk about our New Hampshire pregnancy leave law. This is a law under RSA 354A that applies to all employers with 6 or more employees in the state. And it provides that all female New Hampshire employees are entitled to job protected leave, unpaid, for the period of her temporary physical disability due to pregnancy, childbirth, and related medical conditions. This is a duration of the leave is not determined by a set number of weeks. It's determined by the person's physical disability resulting from pregnancy or childbirth. So it could be as brief as 6 weeks, or it could be as much as a few months, depending upon the person's physical ability. And the thing to know is that the employee can apply for PFMLI wage replacement benefits during her pregnancy leave, because pregnancy is a serious health condition, so that's covered. And PFMLI can also cover birth of the child, and it can cover to care for the child up to the, during the first year of the child's life. So very similar to FMLA, she can use the PFMLI benefits while she is on pregnancy leave and disabled from both pregnancy and childbirth. But let's say her period of disability ends prior to exhausting her PFMLI benefits. Let's say you got the 12-week insurance plan and her period of disability ends after 6 weeks. She can still remain out under a PFMLI until she exhausts those benefits. If the person's disability ends before she becomes eligible for PFMLI benefits, let's say she just signed up for the individual plan and she was in her 7-month waiting period under the individual insurance plan and had her baby and was able to come back to work, then her 7-month waiting period is over. She now qualifies to apply for PFMLI benefits under her individual plan. She can take that PFMLI leave under the plan, because at that point she had a whole new separate leave benefits that kicked in after those 7 months. So that's something to be aware of going forward. FMLA. Now, the PFMLI is intended to align with FMLA, so that FMLA is our federal family medical leave law that provides certain employees who qualify with up to 12 weeks of again, unpaid leave, right? For a lot of the purposes that are the same under the PFMLI benefit plan. But FMLA and PFMLI do have some differences. And in some instances, PFMLI is going to be a broader leave law than FMLA. So how does that work? So first, under the PFMLI law, it defined family member very broadly. It said it could include a child or parent, but it could also include a child's spouse or domestic partner, or a grandparent, whether that be biological, adoptive, or foster, or step, or not just a spouse, but a domestic partner, which under FMLA, it's a much more restricted definition of family member, and it's only a parent, child, or spouse of the employee. But it's a broad, but family member is defined much broader in the PFMLI law. However, when they also went to define what it meant to care for a family member, that's when the definition of family member aligned more with FMLA, which was the employee's spouse, son, daughter, or parent. So I'm interested to see what in fact will be how your insurance policy reads when it says who can qualify for the wage benefit and the leave, the wage replacement benefit and the leave. Will they define family member broadly, or will they define it more restrictively under as under the FMLA? So that is one thing to note, to pay attention to. If you do purchase one of these plans, understand how they define family member, because it was pretty confusing in the law itself. PFMLI can be taken continuously or intermittently, similar to FMLA, but it can be applied only no less than 4-hour increments. Whereas FMLA can be an intermittent leave or reduced schedule can actually be down to even a small increment of an hour. So that's another little difference there. FMLA does not have a 7-day elimination period. PFMLI does. So PFMLI benefits kick in after 7 days of the qualifying reason for the leave, which means that technically the PFMLI, I think the benefits could extend a week beyond your 12 weeks if you have a 12-week plan, or a week beyond your 6 weeks if you have a 6-week plan, because the person has had a 7-day elimination period. Well, FMLA would start day 1 of the person's leave, not day 7 of the person's leave. So in that respect, PFMLI extends it out a little bit more. The other big difference, I think, between the two laws is that FMLA applies eligible employees, or I should say, back up, employees are eligible for FMLA leave once they have worked 12 months for you, for the employer, 12 consecutive months, and at least 1,250 hours. And then they qualify to take FMLA leave. But and they also have to be an employee that is within 50 employees within a 75-mile radius. Those restrictions are not present in the PFMLI leave. So if you are an employer who has signed up, a large employer who has decided to purchase PFMLI insurance, know that it's going to apply to employees from day 1, part-time and full-time, and they don't have to be within a 75-mile radius of 50 or more employees. So those restrictions aren't in the PFMLI leave, and so therefore you could have employees qualifying for PFMLI well before they qualify for FMLA leave, but still get provided the same leave if you're a large employer. So that's another big difference. So some of the takeaways that I have on this, the first thing is the proof is going to be in the price, right? Because the biggest unknown is what are the costs of the premiums under the statute or under these plans. And that's something that unfortunately you're only going to know once you ask MetLife for a quote. And so you may want to start discussing now with your benefits brokers for 2023. If you're interested in getting a quote from MetLife, I would suggest you kind of do it sooner rather than later. I think there'll be more of a rush as we get closer to the end of the year. But that's going to be certainly a big key factor here. Between now and December, talk about getting a quote, but also think about if you want to sign up for maybe bookmark that PFMLI state website, keep visiting it periodically to see if they update their FAQs, if they reschedule more webinars for employers, and hopefully there'll be more information about the business enterprise tax credit on that as well. The next thing you want to do between now and December is assess whether you want to offer it, given what you already have for leave policies or paid leave benefits. I have some employers who are already saying, well, I've got a paid leave policy. And it's like, well, we need to take a look at it, because in order for you to say, I don't need PFMLI, you want to make sure it's comparable to what a PFMLI benefit plan would be. If you have, let's say, a group short-term disability policy, many employers have that, then know that that benefit would run first. All right. But once it's exhausted, if there's no other benefits that the employee is eligible for, if you purchase PFMLI or if they purchase an individual plan, they could apply for those benefit leaves under PFMLI and still extend their leave. So that's something you want to pay attention to. And keep in mind that you may not need a separate short-term disability plan because PFMLI insurance also includes time out for the employee's own serious health conditions. So again, you want to look at those cost factors to decide which is more cost effective, which is going to be more useful for my employees. And then think about how you may need to make change. If you decide to purchase one of these plans, you're going to have to make maybe some changes to your PTO plans, your sick leave plans, and your other benefit plans. And especially if you're if you have 50 more employees and you have an FMLA plan, you're going to want to make sure you have coordination with the PFMLI benefit plan and your FMLA plan and your New Hampshire pregnancy leave policy as well. If you have more than 50 employees, again, total employees, no matter where they're located, but you don't purchase PFMLI insurance, which is fine, you can do that, but just know that you're still going to have to set up the payroll deductions if you have employees, New Hampshire employees, who purchase their own individual plan. Small employers with less than 50 do not have to do the payroll deduction. But all employers will have to cooperate with MetLife on claims processing and providing them with the information they need in order to set up individual plans for your employees. So keep that in mind. Then you can also consider just providing your own employer-sponsored paid leave benefits for either 6 or 12 weeks for the same types of reasons. Doesn't have to be full pay, it can be at 60%, could be something else. And it might be that might be a better way to go for you. That's something you want to talk to your accountants, your tax people, once you know what all the costs are involved here. Or you can do nothing, right? PFMLI is voluntary. And so you don't have to purchase it. You might have a few other little obligations if you're a large employer, but you don't have to purchase it. But keep in mind that it could provide you with a cost-effective benefit if you're trying to recruit or retain people, depending on the type of workforce you have. It could be something that could be very useful for them. And again, it's going to be proof is in the price, right? So you need to know what that cost will be. So that is the end of what I have on my slides for presentations. And I think now we can open it up for questions.
Andrea, all right, we've got a bunch. First up, someone is saying that I was in a webinar last week, and I was told that this was available only for employers with 50 or more employees. That sounds inaccurate based upon your first slide. I think you covered that, but why don't you just review that, please? Absolutely.
Yeah, I'm sure there's going to be, like I say, there's a lot to unpack about this law. But no, it's certainly, if I had a whole slide on small employers that you can absolutely, as a small employer with less than 50 employees, you can absolutely decide to purchase one of these PFMLI plans. And so, yeah, it's something that is available for purchase for small employers with less than 50 employees, as well as individuals, right? People who work for you that
yeah,
you don't purchase PFMLI.
Great, and my apologies for jumping in there. I've got to lay off the double caffeinated and go back to decaf again. So, so you did cover this one as well. And does family member need to be in the same household? Can it be an elderly parent who doesn't live with the employee? And that's getting to be certainly commonplace these days. And I think the other part of it is, I think you talked about the differences between the definition in FMLA and the paid family leave.
Yeah, no, that's a good question too. A family member is defined as a person's parent. There's no requirement that the person live with the employer. I'm sorry, with the employee. So it would apply to an elderly parent who's living on their own or living in an assisted living place, something separate from the employee, certainly would cover that. And whether it's PFMLI or FMLA, parent is going to be defined as parent. But they might include parent-in-laws in the PFMLI, so you want to keep an eye on that. But what as I understand, in order to get the wage replacement benefit, when a person is covered by this insurance plan and they apply for the benefit to use it to care for an elderly parent, then they have to have they may be required by MetLife to have some sort of proof of the parent's either relationship or serious health condition that the parent has that's requiring the employee to care for them. I'll give you a great example. My mother-in-law became extremely ill with Alzheimer's and had needed really around-the-clock care. And my sister-in-law was able to take FMLA leave to care for her. My sister-in-law didn't live with my mother-in-law, but really needed to be caring for her. So she just had to have proof of my mother-in-law's serious health condition and the need for care. And that was sufficient for her employer under FMLA. So under PFMLI, the employee would probably have to provide that proof to MetLife. And as the employer, you could probably, whether you require the same proof or not is up to the employer at that point.
And you did talk about other forms of employer leave up to the employer and the design of their policy being applied here. But there's a question here, just to clarify, the benefit doesn't run concurrently with STD or LTD. It's either or, is that correct?
That's correct. It does not run concurrently with those two. STD and LTD would probably apply first. Doesn't run concurrently, might run after an STD plan is exhausted, but they don't run concurrently. Because in other words, the employee would at that point be double dipping between PFMLI wage benefit and the STD policy benefit, and that would be double dipping. That's called, that's under that phrase called coordination of benefits and coordination of coverages. You see that with health insurance too. They want to know if you have a secondary health plan because one will take precedent over the other. In this one, it's pretty clear that if the person is covered by an STD plan or LTD, those benefits apply first.
Yeah, and for audience members who are just waking up, by STD, we mean short-term disability.
Sure, but yeah, and
Yeah.
LTD is long-term disability. Yep.
Yeah, but not the other definition of STD. Okay.
Yeah.
Okay.
Very true.
Which could be a health condition that someone might have to attend to, but okay. Please clarify. We have a physical location in New Hampshire. Our remote workers that live, and I just skipped beyond this, hang on for a second, that live and work in New Hampshire are covered even though they don't work outside of our physical location. So say that again, we have a physical location in New Hampshire. Our remote workers that live and work in New Hampshire will be covered even though they don't work out of our physical location here. They're remote in New Hampshire.
That is correct. If you have, yes, and I'll reword that a little bit too. If you have a physical location in New Hampshire, let's say it's in Manchester, but your employees are full-time remote, but they live and work in other towns in New Hampshire, then yes, you would be covering, you can cover them under your plan. Yes.
Yep. All right. And then 50 staff, whether part-time or full-time for purposes of the head count for 50.
It's part or full-time, doesn't matter, because in insurance world, they consider each person a life. And so they say if you have 50 or more lives, and so that would cover anybody no matter how many hours they work.
Yeah, and unlike the ACA, which looks at 30 hours, right? And other under the FMLA, other definitions, this is
right.
Part-time, full-time. Okay.
One thing I don't know, and I'm curious, I guess this is something that would be worked out if you're getting a quote, is whether you can choose to exclude certain employees and only cover others, or whether it has to be your entire workforce. That I have not seen clarification on, and that would be a question you want to ask if you're going to get a quote. So in other words, could you exclude people for a certain period of time because they're new, and like you do with a lot of STD or LTD policies, you can exclude people unless they've worked for you for a year or that type of thing. I don't think you can do that, but that's something that would be a question for MetLife.
Yeah, and if this isn't effectively an insurance policy, that could potentially be an ERISA question too, and the way
Yes.
your plan is designed and implemented. So yeah, I think that's, and like we said at the outset, I mean, you're going to find, we have 35 questions still in the queue here, and I think that is representative of what we're going to be seeing and what you've seen before, and that what we saw in Massachusetts, there'll be lots and lots of questions, and I think what you did for Mara last week in your presentation, which was, we don't know yet. This is our best guess at this point, and we're going to continue to follow up with the state and also with MetLife. And I would say MetLife probably doesn't have all the answers either.
Yeah, they may not. I'm sure I'm sure employers are gonna come up with questions MetLife hasn't thought of yet. But what I hope you take out of this is that you can make a checklist of the things you would want to check on as you go through and decide whether, you know, the policy proposal makes sense for you or not.
Yeah. Speaking to individual plans, is short-term disability a similar benefit if it is offered by the employer? And I think you covered that before, which is you talked about employers substituting in similar benefits, but STD and LTD are not substituted in. It's right.
That's right. That's correct. Right. And I think what that means is it's based on, you know, what's your cost, and not only a STD benefit insurance plan, but also if you, the employer, have already implemented a policy in your own that you would self-fund a paid medical leave for a period of time, or paid family leave, or paid parental leave for family, you know, for a period of time out of your own pocket, out of your employer's own pocket. So you've got that. If you've already have that in your policies and employee benefit package, then you want to compare costs, right? Well, do I keep those, or do I replace those with PFMLI because the cost is better, it would cover more people? Or does that, you'll want to do that cost benefit analysis.
Yeah. And you know, obviously, we've got very attentive HR professionals, CEOs, CFOs watching this program this morning. Our questions continue to multiply. And so
That's why I'm glad I finished my presentation earlier.
Which is
early.
Good. It's good because
Be here a while.
we live in the world of worst case scenarios where it's not, we just don't blindly accept these things. And because these leave policies and the multiplier of state and federal policies over the years become this awkward intersection. They don't neatly fit together. So here's a question. If an employer does offer STD and or LTD, would the employee need to use that first before PFMLI?
Yes, that one that MetLife was very clear about.
Okay. Is there job protection for employees if they are buying an individual plan? So it's not the employer sponsored plan, but an individual who elects it and the employer is making the withholdings. Is there job protection for that individual?
It's a good question. And my reading of the New Hampshire statute is no, that they would not have the same job protection rights or protection that a employee would have under the employer plan. And that is because RSA 275-37D says applies to employers that have 50 or more employees and who also sponsors a family medical leave insurance plan under the state scheme. So if you don't have PFMLI, if you don't purchase it, and an employee has individual coverage, then they don't have the job protection right under the PFMLI law. They may have job protection rights under FMLA if you have 50 or more employees and the person qualifies for FMLA. They might have job protection rights if under an ADA scenario or New Hampshire anti-discrimination law, which requires reasonable accommodation for a person's disability. So if the person is needing the time off for their own serious health condition and it's a disability, having a 6 or 12-week leave may be considered a reasonable accommodation to protect their job during that time. So so there might be other laws that would require impose job protection where even though PFMLI would not.
Yeah, we've joked about this, but I think HR professionals that are implementing this program, they themselves may take advantage of PFMLI because of the mental stress in dealing with this. So, and let's go to the next question. Does an employer have to pay at least 50% of the premium costs to be eligible for the 50% tax benefit?
Good question. No, I feel like that might be a person who's been under the mass law. But no, it is 50, the tax credit applies to 50% of whatever amount the employer pays for the premiums for a 6-week plan. So if the employer pays only 40% of the premium applies and has the employee kick in 60% of the premium, the employer would get a tax credit on 50% of that 40%. That makes sense. So it's 50% of whatever the employer pays towards those premiums for a qualifying plan.
I have to smile here because typically when you go through a program like this, in time, especially at the start of a workday, people start to peel off after a while. I've never seen this before. We actually have more people joining now. It's almost like someone opening their door and saying, "Hey, Steve, you got to come down and hear this stuff." So Andrea, I've never seen this before. We've actually had in the last couple of minutes more people join than
Wow.
we had before. And we had over 300 people start the program. We've now and more people are joining. So it's like very
Wow.
interesting. So and it shows what a hot topic this is.
It is, yeah. Glad to see there's a lot of interest in it.
If we do not purchase a plan as the employer, can we subsidize the premiums from the employees who purchase the individual policies?
That's an interesting question. I don't know. I'm trying to think what would prevent you from doing that.
I mean, I guess the question is whether that could be a effectively an informal way of sponsoring, but I think more importantly, the issue is it's a taxable benefit. If I'm
Yeah. Yeah, and keep in mind, the individual plans are only supposed to be no more than $5 a week for the premiums. So, you know, I don't know, it could inevitably turn into, you know, sort of like a virtual employer sponsored plan. But that's a really, really good question. I don't think we know the answer to.
Okay, and then we're gonna go to can a
Let me,
large
can I back up? Let me put you this way. You might be able to do it. I just don't know what the inadvertent consequences may be of that.
Yeah, I mean, certainly a taxable benefit, no question, because it's increased the compensation, but yeah, the question is whether or not you effectively an informal plan sponsor at that point, probably not, but like anything else, we are management side lawyers. On the dark side, those representing the individuals, you know, I'm only kidding, but there are ways in which you might find a plaintiff's lawyer that would challenge things. Back to your point with regard to ADA, FMLA, or other job protection rights. So, I mean, this is it's intended to be a benefit. It's not what it was originally intended to be a couple of years ago. It's meant to be sort of the entree into this, but not like other states, like I think, as you said, but still it's subject to some degree of challenge because there are a lot of questions. So let's go to
it's a bit of a grand experiment, I think, because I haven't seen anything like this anywhere else. A lot of times, most other states pass something that's mandatory, like Mass or Rhode Island. This is a new animal, and it's a grand experiment. That the idea was we don't want to impose a mandatory pay benefit on employers. So, but how can we incentivize employers to provide it on their own? And this was sort of what they came up with. So it's a great experiment, but if it works, it could be a really very, very win-win situation.
Yeah, I think politically, the governor vetoed the first version of this because he said it was effectively an income tax, and this was the alternative. But I think it's a recognition, isn't it, that especially coming out of COVID, that employers need to do a better job of recognizing, you know, an individual's need for paid leave when they may not otherwise have that available to them. So let's go to that. Will employers be required? And I think the answer is yes, to notify employees of PFMLI.
Actually, hold on a second. That one, I don't know. No, there is nothing in the law that imposes a notification or posting requirement on the employer for either the group plan. Imagine if you purchase a group plan, you'll have to have some sort of written notification of what the group plan is, like you would with any other employee benefit under ERISA law. But there is no notification requirement under the law that I saw that you have to put something out there about your rights or your rights to purchase an individual plan or your rights under the plan. I have not seen that.
I guess what I was thinking, we're coming into the open enrollment season, and if
absolutely, yes, yeah. If you're going to purchase the plan as the employer, then you will have written notifications that you have to give employees about what the plan is and what the benefit is, and what the cost of the premium will be to the employee if some or if nothing.
Yep. So that because there was that election period, right? By the employees' election period by what, end of December, early January, right?
That's a good question. I don't know. I don't know.
Yeah.
How that's gonna work, whether there will be an election period that the employees sign up, or whether like a lot of, in other words, there's gonna be like a voluntary short-term disability plan where the employee can choose to sign up. If, I would think that would apply if if you're shifting the cost of the group plan to the employee. But if the employer is paying the full cost of the premium, there's no election by the employee needed at that point.
So let's go to the individual. If the employer does not purchase a plan, can it still require that PFMLI that the employee elects run concurrently with FMLA?
Yeah, so if the employer is FMLA covered, they don't purchase PFMLI, the individual employee has an individual plan. Oh, yes, then they can run concurrently, yes.
Yeah. All right, I'm rolling through our questions here.
So again, another reason to, when you have that, if you have that situation, something to look at on your FMLA policies in general, to make sure you've got something in there about that leave time under this policy, FMLA, and any other employer policy or any other employee benefit plan would run concurrently.
Is there a minimum employment period of hours or of hours worked to be eligible for PFMLA, similar to?
Not that I've seen,
Yeah.
not
right.
that I've seen.
Similar to the
Yeah.
FMLA, 12 months, 12,
Yeah.
50 hours.
Right,
you were
yeah,
saying
no, it
ear-
doesn't have that, does not have that requirement.
Right, but you're saying earlier, perhaps it could be if you're, as you're designing your plan.
Right, yes, yes.
And the notification, we just covered that. What if the employer offers LTD after our company paid STD? Okay, I think we covered that as well. Where does PFMLA fit in?
Those would control, yep, those would pay first.
Let's see. Here we go. If a Massachusetts employer has a remote New Hampshire employee, but no physical location, can the employee purchase their own plan? So it's a Mass employer with a New Hampshire employee, but the Mass employer does not have a physical location in New Hampshire. Can the employee purchase their own plan?
Maybe not. I believe the individual plans may require that the employee work for a New Hampshire employer.
Yeah. I think that's right at this point.
Yeah.
Okay. I am a large employer who offers STD. Our STD is not effective until 1 year after employment. Can the employee purchase STD through MetLife during this waiting period?
I would think yes. In other words, if you do not yet qualify or have available STD benefits for you, you can get an individual coverage. You might even be able to get PFMLI. The employer might be able to purchase the PFMLI and have the person access benefits through PFMLI if they have a serious health condition. Because keep in mind, PFMLI covers not just your short-term disability of the employee, but also family leave too.
Yep. Let's see. If we don't purchase an employer policy, what are our obligations to let New Hampshire employees know of this new PFMLI benefit? And we talked about that. It's uncertain as to the notification. If it is, we're not purchasing a policy. So you're not going through open enrollment. What notices now? So this program is administered through. It's administered. MetLife is the plan administrator, but there is. What's the State Department that's going to enforce the statute? So it would be the Department of Labor, wouldn't it? Because it's 275-37. So
yeah, 275-37D is under, it's under, so it would be probably Department of Labor. But again, there's no notification requirement. So if you, the employer, decide not to purchase PFMLI insurance, there's no notification requirement to tell employees about the individual plan. It's kind of like up to MetLife to do, publicity blitzes about it.
The only thing I can think of is that provision is at RSA 275-49, which says at the time you hire someone, give them written notification of their payday, their pay rate, their pay period, and a general description of fringe benefits. I wonder if that would be a hook to say, you know, you've got to go somewhere to say, this is the menu of our benefits.
But it's not, if you're not purchasing PFMLI, it's not part of your fringe benefits. And an individual plan is not run through the employer. It's between the individual and MetLife. MetLife, individual has to purchase the plan from MetLife. You might have to do the payroll deduction, but I wouldn't think that would be a fringe benefit that the employer is providing.
Yeah, I
So,
think that's
that's a good question, but that might be a question for Rudy.
yeah, I think that's right. I think it would just be at that point a payroll deduction, and it just has to be clear on a pay stub what you're doing, pay statement.
Oh, absolutely. Yes.
All right, if we decide not to offer PFMLI, are we still required to educate our employees on the benefit because they can opt in on their own? That's entirely up to the employer at this point, right?
Yeah, again, you're not purchasing the plan. There's nothing for the employee to opt into. The employee themselves outside of work can purchase the individual plan through MetLife. And the requirement the employer would have is if they are a large employer, they'd have to do it through payroll deduction. So the employer would get notified by MetLife, hey, you have to do this payroll deduction.
Yeah.
But yeah, if you don't purchase a plan, you don't have to tell them about the individual plan.
But in these days of labor shortages and the need to retain employees, I would imagine employers would just do that, right? If they're not purchasing the plan, certainly if they are purchasing the plan, but if they're not purchasing the plan, they would want to say, hey, you have this option available here. Again, for purposes of, it's informal, but it's a part of a retention plan.
That's true. Yeah. If you're trying to attract somebody maybe to work in New Hampshire, that's very true.
If an employer offers both PFMLI and STD, is the 60% max amount of income they will receive? Is that well out? So there's a no double dipping scenario. Is that correct?
Correct. There's no double dipping. Nope.
Yeah.
MetLife was very clear about that.
And then let's see. For a large employer with 50 or more employees, where it becomes similar to FMLA leave, does it carry the same eligibility requirements? So I think we've covered that as well for purposes of, 1 year, 1250, definition of family, and so on.
Yeah, no, those are not in the law. Those eligibility requirements are not in the law.
Do you have information when PFMLI would be used if the employer has paid leave plan STD as long as the long-term disability plan LTD, which becomes effective once the STD is exhausted? I'm going to read that again. Do you have information when PFMLI would be used if the employer has paid leave plan STD as well as long-term disability plan LTD, which becomes effective once STD is exhausted?
Interestingly enough, it might. In the one of the MetLife webinars, sort of a similar question was asked, and they said that they're separate benefit plans. So if you have an STD and an LTD, once those are exhausted and you have a PFMLI plan, the person might be able to get benefits under that plan after the STD and the LTD are exhausted. But LTD is that's like really long term, like you're on Social Security disability at that point. So I think it's more a matter of if the STD gets exhausted and you do not have LTD, then PFMLI would probably apply. A lot can happen in that period of time, depending how long you have STD benefits for. Some plans are 26 weeks.
And let's go to this one. How about this? And this is a common question from our friends in HR. With an individual plan, so not an employer-sponsored plan, but an individual plan, does the employee have to use all of their PTO before using PFMLI?
Possibly.
Yeah.
Possibly. I believe the MetLife person said they have a requirement that the person can be required to use all but 1 week of PTO before the STD, but before the PFMLI benefit would kick in under the individual plan. So they can be required to use all but 1 week. They have to have 1 week in reserve.
Right. Let's see. Could you, okay, so it's reviewing the eligibility FMLA versus PFMLI. For example, an employee does not need to meet the FMLA eligibility. How does the PFMLI work? Does the employer have to allow the employee to take PFMLI?
Yes, yes. If you are an employer with 50 or more employees and you've sponsored the PFMLI plan, then any employee who does take benefits and takes leave under that plan and accesses the wage replacement benefits shall be restored to their original position. So they have the job protection rights, similar to FMLA, it says, as well as protection from anti-retaliation and also preservation of the health insurance coverage during the time. So in other words, it's a sneaky way that New Hampshire law is sort of broadening FMLA leave rights.
And question, PFMLI and FMLA, again, if you're covered by the FMLA, run concurrently, and that's correct, right?
Yes, yes. I will say one thing. So the statute, and I'm gonna kind of back up on my, oops, what did I just do? Sorry about that, folks. There we go. I'm trying to get to the slide here. This slide here, you see how I've got that, there's a link here, the RSA 275-37D is a live link to that statute. And that's really what I'm going by when I talk about questions about the fact that this is now a sneaky way of broadening FMLA coverage, because of you don't have to qualify for FMLA in order to get the job protection leave benefits under PFMLI.
Okay.
And what that statute says is that the employers can have PFMLI leave run concurrently with other leaves through either that are in a collective bargaining agreement or under FMLA, under Family Medical Leave Act, or by other established employer leave policy. And so what I say is that for like pregnancy leave, make sure if you want to run your pregnancy leave under New Hampshire law concurrently with PFMLI leave, you want to make sure you have a pregnancy leave established policy that mirrors what New Hampshire law requires. So then you can run them concurrently. And you would note that in the pregnancy leave policy in your PFMLI policy.
We talked about notification requirements, hanging posters not required. Otherwise notifying employees, you may do that, but you're not required to. I mean, that's something that may be, as this evolves, our friends at Labor will require you to post that about eligibility. If they find that people are not enrolling, or if an employer does not, if employers do not sign up for this, or individuals are not enrolling, perhaps they might do it just to alert them to the benefit, but that isn't a requirement now, right? So
could you repeat that?
Just the notification issue. I think we covered that. It just may be that will evolve in time, that
Yes,
notification.
I agree.
Yeah.
Yeah, I agree. Well, I think it will evolve over time.
And here's again another question about the border wars between New Hampshire and Massachusetts. We are an employer located in Mass. Most employees work in Mass, but we do have some remote workers in New Hampshire. Those New Hampshire remote workers can't be covered in Mass, or sounds like New Hampshire either. Are there any options for PFMLI other than STD or LTD that they can get through us?
I think that's right. That they would not be eligible under either state's plans. And again, I'm not aware that they qualify for an individual plan, but they certainly could talk to MetLife about ability to purchase an individual plan, but I'm not sure that they qualify because they're not working for a New Hampshire employer.
Okay. And then another one related to that. How about if we have remotes in other states, but businesses located in New Hampshire, are those employees eligible?
No, the PFMLI would not cover remote employees who live and work in states outside of New Hampshire. Would only cover your New Hampshire centric employees, your New Hampshire employees working in New Hampshire.
And I think I've got a few questions along those same lines. And then, oh, interesting one. Is there a New Hampshire PFMLI similar to that in the Mass PFML in allowing male employees to take time for child bonding?
Absolutely. Yes, the family leave portions of the PFMLI are not gender specific. So absolutely, males would be able to take paid leave if they have a child, either through a female companion's birth, or through adoption or placement for foster care. A male employee absolutely can take paid leave under PFMLI for that.
Okay.
And that's similar to FMLA too.
All right, is there a 7-month waiting period apply only in, is the 7-month waiting period apply only in 2023, or will this apply each year if the employee is newly applying?
Okay, so the 7-month waiting period only applies to individually purchased plans, not the employer group plans. An individual purchases a plan, then they have to be on the plan for 7 months and pay into it for 7 months before they can qualify for benefits. And what is soon to be, we don't know yet, is whether or not, let's say their employment ends in 5 months. Can they continue to pay into that individual plan in order to keep it going? Or does their ability to keep that plan stop until they find employment with another New Hampshire employer? That we do not know yet. And that would be a question for MetLife.
Right.
I'm really amazed at all the questions about the individual plans.
What is, and if you're to forecast, what do you think that means?
That I think employers are going to see if individuals, or would kind of probably want to see individuals purchase their own plan as opposed to getting a group plan. But keep in mind, employers don't get the tax credit for any premiums paid, or for any premiums paid by the employee on the individual plans. And going back to an earlier question about, can we subsidize the cost of the individual plan to employees? As I said, probably, but I don't know what the unintended consequences are, but you certainly will not qualify for the tax credit on your business enterprise tax for doing that.
Yeah, and I think it could be, and I heard this recently, that it might be in that first year, employers will wait to see how their employees are interested in this and sign up. And then perhaps after that, the employers will add it as a plan sponsor.
I agree. I don't know if there's going to be much appetite for the individual plans. I could be wrong, but where it's got the 7-month waiting period, it's only 6 weeks of wage replacement leave. I'm not sure I see individuals go. I mean, it is a nice, it's going to be an affordable premium for sure. But it could be that they're going to wait and see if their employers sign up, and employers are going to be waiting to see if individuals sign up. And so we may have, it might be something that's going to take a few years to get traction one way or the other.
Yeah. So in that regard, let's talk about the administration of the plan. If the employer purchases PFMLI, so it's the employer sponsor, does the employee still need to apply for coverage through the state, or does the employer simply submit a claim on the employee's behalf?
My understanding is the employee has to submit the claim for the wage replacement benefits.
Right.
So, and again, I think it's going to be similar to how STD works, that, you know, if you have a short-term disability insurance plan and an employee needs the time off, they first go to the employer, right, to say, I need time off. And at that point, then I think it's a matter of the employer may have to either remind the employee or prompt the employee to say, hey, you have insurance coverage, either the individual plan or the PFML. I'm sorry, if you have the PFMLI insurance plan, then I think it would be the employer at that point to say, okay, this is what you're entitled to for leave, and here's the application form for you to apply for benefits to MetLife for your PFMLI wage benefit.
Yeah. This is an interesting one because we're seeing a lot of these hybrid arrangements. Physical location is in New Hampshire, meaning the employer is in New Hampshire, and the employee lives in Massachusetts. The employee works remotely 2 to 3 days per week, but also works in New Hampshire the other days.
Yep.
Would
Yep.
they be covered
Okay.
with PFMLI?
Great question. Basically, I'm gonna go back to when you engage or employ the employee, you have to report their wages to one state only for purposes of paying unemployment tax. And that state that you pay into usually is the state in which you consider them to be primarily working in. And it can be in your situation, the person lives in Mass, maybe they work 3 days in Mass, 2 days in New Hampshire. If you're reporting that person's wages to Mass unemployment for purposes of unemployment taxes and their income tax as well in Massachusetts, then the Mass law is going to cover them. The Mass PFML law. If you decide, no, I want that employee to work more of their time in New Hampshire, but even though we're going to let them work from home 2 days a week, let's say, but I really consider them primarily working in New Hampshire, and you report their wages to New Hampshire Employment Security for purposes of the unemployment benefits and taxes, then I would think you can, at that point, cover them under PFMLI, New Hampshire law. If you want me to go through that again, I can. That was a
No,
lot.
I just think it's you're choosing one or the other, and I think that employers are going to look at the benefits and they might even look at what the employee wants. But I think we're going to continue to see. We've talked about this before, Andrea, but in the next year or two, shakeouts with regard to remote work, hybrid work, and so on. And so that this all could be shifting sands in the next couple of years. Either
It could, and I mean, we're seeing it now. I mean, I've got clients that are, okay, we've got an employee, she lives in Boston. Do I have to register under PFMLA for Massachusetts law or not? And it's like, well, how much time is she going to be working from home in Boston as opposed to coming to New Hampshire to the employer's office? And that's a conversation between the employer-employee first to determine what the expectation is. But then the employer's like, well, it's probably going to be split evenly. But the employer then said, but you know what, we're probably going to need to widen our recruitment net to other, we're going to be more open to people hiring people who live in Mass and letting them work from home. So it might be that we want to go with the Massachusetts coverage because we're going to have more people working from Massachusetts. I'm like, okay, so you're absolutely right. It's going to be shifting sands because at the same time, given that nature of that person's job, I said to the employer, make sure you're okay with her working more often in Massachusetts than in your office in New Hampshire, because it sounds like a job that's going to require that person be present on the work site more than not. And you're right. So it's going to be shifting sands.
Yeah.
I agree.
Let's go back to that potentially awkward intersection between FMLA and PFMLI. Would it be possible for someone to take PFMLI for something that does not qualify for FMLA and then take FMLA for something else, potentially resulting in 2 12-week protected leave periods?
Yes. Yes, because they are still two separate benefit laws. And so they could easily qualify for one and take leave under that. And then when that's exhausted, they may then qualify for the other and take leave under there.
That alone could cause some HR professionals to walk into the C-suite and say, yeah, we're not going to do that right now.
I know.
Yeah.
Yep. That's one of those. Yeah, I agree. That could be an unintended consequence. Whether or not, again, you may jot down a question from MetLife. Can you make some sort of provision in the policy about that? I don't know.
Let's talk about, there's a MetLife question here. Individually purchased plans cannot exceed $5 per week. Would the same cap apply to an employer purchase plan through MetLife?
No. What it cannot exceed, I believe, is how MetLife set a group rate that it's charging the state for the state employees' coverages. I don't believe that the employer-sponsored plans would not necessarily exceed that group rate, but in other words, the group rate that the employers get has to be based on similar factors as the group rate was based for the state employees. So in other words, you're getting the benefit of getting a group rate for a large group of employees.
Let's shift to the union environment here. You mentioned that at the outset with regard to CBAs or collective bargaining agreements. Can you explain this a little further? This is a union employer, and as you know, in New Hampshire, mostly public sector unions, but there are some private sector unions. We have have STD and other paid leave benefits that go above and beyond PFML, but none of them are offered to union employees, those covered by the collective bargaining agreement. Similarly, if part-time employees can receive PFML, but we don't offer them STD, does that mean we don't have to offer comparable coverage?
Can you repeat that question?
Yeah, so I'm sort of stumbling through that one too. So this union employer has STD and other paid leave benefits that go above and beyond PFML, but none of them are offered to collective bargaining employees. So that's to non-union employees. So similarly, if part-time employees can receive PFML, but we don't offer STD to them, does that mean we don't have to offer comparable coverage?
That's going to be a question from MetLife. And that goes back to whether when you get the quote from MetLife, whether it's got to be for all your eligible employees performing services in New Hampshire, or can you carve out certain groups like either people who work less than 20 hours or new employees, that type of thing.
Yep.
I'm not sure that is going to be allowed, but it's a question from MetLife, how they devise and how they develop their plans. And then I think you also mentioned that under ERISA, you want to be careful that you're not blowing any non-discrimination testing requirements too, under ERISA plans.
If insurance covers up to 60%, is there a wage cap for that? For example, some STD plans offer 60% up to $1,000.
It's the way it reads is it's 60% of the person's average weekly wage up to the taxable amount for Social Security benefits. That's the wage cap, which in 2022 was $147,000. So 60% of the average weekly wage up to a rate similar, up to a rate equal to 147,000. That's where the cap is.
Okay, and I'm skipping down here. For someone on maternity leave, we make employees whole for 4 weeks during STD, then pay them 100% of the pay for an additional 4 weeks. Would the employee then be eligible to extend their leave by enrolling in PFMLI, giving them an additional 12 weeks of leave?
If the employee is enrolling in an individual plan, they can apply for the benefits and get them. You may not necessarily have to provide the leave, the job protected leave.
Yeah.
If the employee is claiming PFMLI benefits through the employer sponsored plan, then my understanding is possibly yes.
Okay.
That they would be able to extend and have the job protection for that period of time.
And then we've got, so as a municipal employer, we don't qualify for reimbursement, but also can't offer PFMLA.
Yes. I mean, you can certainly purchase PFMLI insurance, even though you won't get the benefit of the tax credit. Yes, absolutely.
How would this benefit work with a sick bank benefit under the CBA, a collective bargaining agreement?
My understanding is that the sick bank benefit would obviously be applied first. And if you purchase PFMLI insurance, PFMLI could qualify, the person could be eligible for PFMLI after that sick bank. That's why you want to really look at your current benefit plans. I mean, if you have a very generous sick bank benefit for your employees that covers, well more than 6 weeks or 12 weeks of paid leave at full pay, that's great. You won't need PFMLI for the employee's health condition. What you may want to ask MetLife is, well, can you quote me a plan that's doesn't include this employee's serious health condition, just includes paid benefit leaves for the family based reasons for leave. You know, that the employee's spouse or child has a serious health condition, or it's the bonding period after birth, or it's for the adoption of a child, those family-based reasons. What I don't know is if MetLife would quote you a different premium for just that coverage versus the full PFMLI coverage that would include an employee's serious health condition.
Very interesting question, and I was thinking of this earlier too. So collective bargaining agreements are typically not for 1 year. They're typically from anywhere from 3 to 5 years. So say if you're midterm in a collective bargaining agreement, the question is whether or not this benefit, if it's an employer-sponsored plan, would have to be negotiated as a part of an amendment to a collective bargaining agreement, because employers may not be able to offer it unilaterally to union members without having a problem.
Yeah, my thought, and again, I don't do a lot of union law. I don't know, Jim, if you do, but my thought is, if it's an add-on benefit at no cost to employees, I don't know if you have to negotiate that. But if it is a benefit you're adding to replace something else in the collective bargaining agreement, or if you wanted to shift some or all of the cost of the premiums to the employee, then I would imagine that you would have to negotiate,
Yeah, if it's terms
because
and
that would
conditions,
be an amendment.
if it's terms and conditions of employment, you want to avoid a situation of employer pacification or unilateral action. I don't think it fits under management rights. I don't know. I would assume that you have open up your discussions with with the union representatives and say, this is what we'd like to do, and have some discussion. But you couldn't go, I guess you could go beyond what PFMLA offers. It's just that you have to stay within the lines of what the PFMLA law is. You can offer a greater benefit if you want to, but again, that would be negotiated. Interesting. I think, again, New Hampshire doesn't have that many unions, but for those that are union employers, I think that would be an important question if you want to offer that benefit.
Because I know, like, the state as an employer has state employee unions. I don't know if they had to get the state employee union's approval to get the plan, because the plan is being offered at no cost to the employees. So it's an add-on, and in that situation, I don't know if they had to get any type of union approval or pre-notification to the union. I know they were notified of it because it was in the proposed law. But I don't think the union had any objection to it, because it wasn't going to cost their employees anything. It was going to be an add-on benefit.
I'm going to just go because we're run out of time here, and oh my gosh, we still have several questions remaining. Let's go to, again, job restoration is only for large employers.
Yep, with 50 or more total employees.
Yeah. And we did talk about the enrollment period. Can someone purchase an individual plan at any time?
No, the individual plans can only be purchased during a 60-day enrollment period. That will be, I think, at the beginning of each calendar year. But employers can purchase the group plans at any time.
And then the final questions I'm going to go with is, we have an STD plan that is 100% employee paid. Can we terminate that plan and go with this one?
Yes, yes, you can.
I would compare
Again,
that.
you're going to want to do your cost benefit analysis on it.
Yeah, I would compare that to when I was in graduate school. Before law school, there was a tax professor who said, when you go to amend the tax code, it's like sticking your hands into a running engine to tune it. Similarly, you're going into, when there's an STD plan and you're looking to change it somehow, be careful, because you may have someone on that benefit at the time, and you want to make sure it's an even transfer.
Oh, absolutely. Yeah, I think actually with STD benefits, the person continues to get the benefit if their employment ends, as long as they became disabled while they were employed, the benefit continues, whether or not employment ends while they're collecting benefits, while they're disabled, as long as they're disabled and they haven't exhausted the plan benefits. But I think it's still a matter of, you want to make sure that, you know, it's not going to be apples to oranges, right? I mean, the STD plan is probably it might exclude part-timers. It only applies for the employee's serious health condition, whereas the PFMLI benefit could cover all your employees, full and part-time. I think it will, and then also covers other reasons other than the serious health condition. So it's probably going to cost more than your STD, but because it's going to be covering more, and that's where you do the cost benefit analysis. Is, hey, having an ability to provide paid family leave as well as paid medical leave, is that going to help us with attracting workers, as opposed to just having an STD benefit plan?
Well,
And keep in mind too, if you purchase the PFMLI plan, you get the tax credit for the BET tax.
and
Whereas
you know,
don't for the
for those that watch late night TV over the years, you know that when those Ronco commercials came on, they would always say, how much would you pay for? But wait, there's still more. I think it's fair to say, Andrea, there's still going to be more coming from this. In the meantime, remember that this program received SHRM credits. All attendees will get that. And actually, you have the code right there on the screen. You'll be getting, Liz Tesic will be sending out a copy of today's program along with the video and the live links. But I want everyone virtually to give a standing ovation to our friend Andrea Chatfield for an amazing presentation today, the time that she's taken to dig into this and answer a lot of very tough questions. But thank you, Andrea, for taking the time. Great presentation, and certainly more to come. And Andrea, any closing remarks?
No, other than, more to come. Grab your second cup of coffee of the day, because you're going to need it. I, welcome any other questions that people might have. And actually, if you do go for quotes, it would be interesting to share your experiences either on LaborNet or with Jim or me, because I think this is something we're all in that wait and see period. And if you learn more information through getting quotes from MetLife, why not share them, right?
Well, thanks again, Andrea. And great rest of the day to everyone else. Thanks for joining us today.
Bye-bye.